Okay, we've got major breaking news, a major loss in court for Donald Trump in the civil suit brought by the New York Attorney General Tish James. A New York state judge has just ruled that Donald Trump committed fraud by exaggerating the value of his assets in financial statements. This was a major plank of Tish James's case against Donald Trump. That case is set to go to trial on Monday. Donald Trump's attorneys had also asked to throw out the case, and the judge denied that request.
Trump just got hit with the most devastating evidence dump in court, and what prosecutors presented could change everything. This isn't some minor legal setback. This is prosecutors standing up and showing judge exactly how Trump orchestrated massive fraud scheme and then tried to cover it up by destroying evidence. And here's what makes this absolutely catastrophic. Trump's lawyers had sworn under oath that all documents were produced, that financial statements were accurate, that everything was legitimate. And then prosecutors presented emails, financial records, internal memos, all proving Trump's legal team just lied to the court. And if this pattern continues, if judge rules the way legal experts expect, Trump could be facing immediate detention, not bail, not house arrest, actual jail time while awaiting trial. But real quick, before we get into this, let's be honest. You can't really trust mainstream media anymore. That's why we built Patrick Smith's show to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, please subscribe, because you might think you are, but aren't. Your subscription actually matters here. All right, let's get into what actually happened, because this evidence presentation was absolutely brutal. New York judge already ruled that Trump committed fraud by exaggerating value of his assets in financial statements. That's not alleged anymore. That's established fact. Judge found Trump liable. But what prosecutors presented goes way beyond that initial ruling. They're showing systematic pattern of fraud, intentional evidence destruction, lawyers committing perjury. And if all this holds up, if judge accepts this evidence the way it's being presented, Trump could be looking at criminal charges that carry serious jail time. Share this video with everyone you know. And let me walk you through what prosecutors actually showed. First, they presented emails from Trump Organization executives discussing which documents to eliminate before court deadline. One email literally says, "We need to review valuation files before producing them." Another asks what to do with appraisals that came in low. Response says, "Use your judgment, but we don't want those files confusing narrative." That's not innocent document management. That's conspiracy to destroy evidence under subpoena. And if prosecutors can prove Trump directed this, that's obstruction charge right there. Then prosecutors showed actual financial documents that Trump's team claimed didn't exist or were already produced. Property appraisals showing Trump's assets worth fraction of what he claimed. Bank records proving inflated valuations were used to secure loans. Side-by-side comparisons showing Trump's golf courses valued by independent appraisers at $75 million, but claimed on financial statements at $350 million. His penthouse at 11,000 square feet, but claimed at 30,000. Property after property, same pattern. Inflate value, get better loan terms, destroy evidence of real value. Think about what that means, and here's where it gets really interesting. This is exact same fraud that got Allen Weisselberg sent to jail. Trump's CFO already served time for lying about these property values, specifically about that penthouse square footage. Weisselberg went to prison for 5 months in 2024 for perjury about those exact numbers. And prosecutors just showed that Trump's current legal team was still using those same false valuations even after Weisselberg's conviction. That's willful systematic fraud that Trump knew was illegal because his own CFO already served time for it. If judge makes connection explicit, if ruling says Trump watched his CFO go to jail for this exact conduct and continued doing it anyway, that shows contempt for law at highest level, and that's type of finding that could lead to immediate detention order. Because if defendant is actively destroying evidence and continuing fraud even after watching associates go to prison for same conduct, judge has every reason to believe defendant won't comply with any court order while free. Here's where prosecutors really drove the point home. They didn't just show fraud, they showed Trump's lawyers potentially committed perjury about it. Trump's legal team submitted sworn statements saying they'd produced all relevant documents, that financial statements were accurate, that they'd complied with all court orders, and prosecutors just presented evidence contradicting every one of those sworn statements. Documents that were supposed to be produced, but weren't. Valuations that were supposed to be accurate, but were inflated by hundreds of millions. Evidence that was supposed to be preserved, but was destroyed. If judge finds Trump's lawyers lied under oath, that's separate criminal matter, and it leaves Trump without credible legal representation right when he needs it most. Because what lawyer wants to take case where previous attorneys are being investigated for perjury? Now let's talk about the specific properties because details matter here. Prosecutors focused on several key assets where pattern of fraud is undeniable. Trump National Golf Club in Los Angeles. Independent appraisal said property worth $75 million based on actual revenue and comparable sales. Trump's financial statements claimed $350 million. That's not rounding error. That's not aggressive valuation. That's fraud. Claiming property worth almost 5 times its actual value to get better loan terms. Trump Tower commercial space. Real value based on actual rental income around $20 million annually. Trump claimed $60 million. Triple the actual number. Used that inflated figure to secure financing and insurance at rates he didn't qualify for based on truth. Mar-a-Lago. Real value as private club may be $75 million considering deed restrictions that prevent residential development. Trump claimed $750 million by pretending he could subdivide property even though deed explicitly prohibits that. 10 times actual value. Share this with everyone because Manhattan Penthouse is where fraud is most obvious and provable. Penthouse is 11,000 square feet. That's documented in building plans. Multiple people measured it. No dispute about actual size. But Trump's financial statements from 2012 through 2021 claimed 30,000 square feet, nearly triple actual size, and Trump used that false square footage to justify property value of $327 million. That's textbook fraud. Intentionally misrepresenting material fact to obtain financial benefit. And we know Trump knew it was fraud because Alan Weisselberg already testified about this. Said Trump personally directed him to use 30,000 square foot figure, even though they both knew real size. Weisselberg went to jail for that lie, served 5 months, got out, and prosecutors just showed Trump's team still using valuations based on that same inflated penthouse size. After Weisselberg's conviction, after everyone knew it was fraud, Trump just kept doing it. If that's what evidence shows, if judge accepts prosecutor's presentation, then ruling could say defendant continued committing fraud even after watching CFO imprisoned for same conduct. That demonstrates defendant has no respect for court orders or legal consequences, and that's exactly type of finding that supports detention without bail. Because how do you trust defendant to comply with future court orders when he ignored previous convictions and kept committing same fraud? Now let me explain the cover-up evidence because that's potentially even more damaging than original fraud. Prosecutors presented emails from January 2026 right after judge ordered Trump to produce financial documents within specific time frame. Emails show Trump organization executives discussing which documents to provide and which to eliminate. One email from General Counsel says, "Need to review all valuation files and only produce documents that support our position." Another from accountant asks what to do with appraisals that came in low. General Counsel responds, "Use judgment, but don't want those files confusing narrative." That's not legal advice. That's instructions to destroy evidence. And prosecutors had witnesses. Former Trump Organization employees testified they were ordered to shred boxes of financial documents. One witness said she personally fed old property appraisals into industrial shredder. Another said he was told to delete digital files containing valuation comparisons. Prosecutors brought in digital forensics expert who testified that hundreds of files were permanently deleted from Trump Organization computers during investigation. Files with names like Property Appraisals 2015-2020. These weren't accidentally deleted. Experts showed deletion happened in concentrated period right after subpoena was served. That's intentional evidence destruction. And if Trump directed it or knew about it, that's obstruction charge on top of fraud charges. Think about what that means. Here's what makes all this potentially leading to immediate jail. Trump already has conviction in New York for business fraud. Attorney General Letitia James prosecuted him in 2023-2024, presented evidence that Trump systematically inflated net worth to get better loans and business deals. Judge found Trump liable, ordered him to pay $354 million in penalties. That conviction was upheld on appeal. So Trump's already been found guilty of this exact fraud in civil court. And now prosecutors are showing he continued committing same fraud even after that conviction. If judge makes that finding explicit, if ruling says defendant was convicted of fraud, ordered to pay hundreds of millions in penalties, and instead of stopping continued fraud and obstructed court's investigation of it, that's pattern of lawlessness that could demand most severe consequences. And most severe consequence in this context is detention pending trial. Because here's how judges think about bail and detention. They ask two questions. Is defendant flight risk? And is defendant danger to community or to integrity of judicial proceedings? On flight risk, Trump has resources to flee and connections to countries without extradition. On danger to proceedings, if evidence shows Trump actively destroying documents and lying to court, judge has reason to believe he'll continue obstructing if left free. That's textbook case for detention without bail. Now, I want to be clear about what this means practically. If judge rules the way prosecutors are arguing, if all this evidence is accepted and findings are made, Trump could face order for immediate detention upon any future arrest. Not might face. Could face based on pattern of conduct being established, and that would be unprecedented for former president. But it would also be legally justified if fraud and obstruction are proven to degree prosecutors' claim. Let me explain how this connects to potential criminal charges. Right now, this is civil fraud case. Judge already ruled Trump liable, but evidence prosecutors are presenting could form basis for criminal charges. Manhattan DA could look at same evidence and charge Trump with criminal fraud, with obstruction of justice, with conspiracy to destroy evidence. Those are felonies carrying prison time. And if those charges are brought based on this evidence, and if judges' findings in civil case establish pattern of ongoing fraud and obstruction, then detention without bail becomes real possibility. Because criminal defendant who's already been found liable for fraud in civil case, who continued committing fraud after civil conviction, who destroyed evidence under subpoena, who directed lawyers to lie to court, that defendant is not good candidate for pre-trial release. That defendant has shown they won't follow court orders, won't stop committing crimes, won't preserve evidence, so detention becomes necessary to protect integrity of proceedings. And timing matters here. All this evidence is coming out right, as other legal pressures are mounting on Trump. He's facing potential impeachment if Democrats take House in 2026. He's dealing with multiple investigations. His approval ratings are falling, political support eroding, and now prosecutors are building case that could lead to criminal charges with detention. All of it converging, all of it accelerating, all of it pointing toward accountability that Trump has avoided his entire life. Now here's where Venezuela operation comes back to haunt Trump. Just days ago, Trump ordered arrest of Venezuelan President Maduro, invaded Venezuela, captured their president, brought him to US to face charges. Trump celebrated it as enforcing rule of law against corrupt dictator. Said no leader is above law. But now Trump himself could be facing arrest for fraud and obstruction. And contrast is devastating. Democrats are already preparing ads showing Trump's statement about Maduro next to evidence from fraud case. Message is clear. Trump thinks law applies to everyone except him. He'll arrest foreign leaders but resist accountability for his own crimes. That hypocrisy resonates with voters. Hurts Trump politically even if he avoids criminal charges. Because it shows he doesn't believe in principles he claims to enforce. Think about what that means. And here's what legal experts are saying about where this goes. If prosecutors' evidence is as strong as it appears, if judge accepts their presentation and makes findings about ongoing fraud and obstruction, then referral to Manhattan DA for criminal charges is almost certain. Can't have civil court establishing that defendant committed fraud, destroyed evidence, and directed perjury without criminal prosecutors taking interest. That's their job, to prosecute crimes. And if crimes are proven in civil proceeding, criminal charges follow. Manhattan DA Alvin Bragg already prosecuted Trump once, got conviction on 34 felony counts in hush money case. so he's not afraid to charge former president. And if evidence of fraud and obstruction is handed to him on silver platter by civil court findings, he'll probably bring charges. Question is timing. Does he wait until after 2026 elections? Does he move before Trump's term ends? Does he coordinate with federal prosecutors? All unknowns. But direction is clear. Criminal charges are coming if evidence holds up. And if criminal charges are brought, if Trump is arrested on fraud and obstruction charges, then judge's detention decision becomes critical. Based on pattern of conduct being established in civil case, based on evidence of ongoing fraud and evidence destruction, judge could order detention without bail, could say defendant has shown he won't comply with court orders, won't preserve evidence, won't stop committing fraud, therefore detention necessary pending trial. That would mean Trump in jail while awaiting trial, not house arrest, not monitoring, jail. Because if evidence shows he destroyed documents while under court order, how do you trust him with house arrest and electronic monitoring? He'd just keep obstructing, keep destroying evidence, keep lying. So secure detention becomes only option to ensure he appears for trial and doesn't continue criminal conduct. Now imagine that scenario playing out. Former president arrested on fraud charges. Evidence shows ongoing pattern of crime and obstruction. Judge orders detention without bail. Trump taken to secure facility. And he's there while still technically holding office or having just left office. That's unprecedented. That's constitutional crisis. But it's also logical outcome if evidence proves what prosecutors claim. Because here's fundamental question. Is anyone truly above law in America? If evidence proves Trump committed fraud, destroyed evidence, directed perjury, and continued crimes even after civil conviction, does he get different treatment because of who he is? Or does he face same consequences any other defendant would face? That's question at heart of all this. An answer determines whether American justice system has integrity or whether wealth and power create permanent immunity. Prosecutors are betting that evidence is strong enough to prove fraud and obstruction beyond reasonable doubt. That pattern is clear enough to justify criminal charges. That conduct is egregious enough to warrant detention. They're presenting case methodically, building record, establishing findings, all pointing toward criminal prosecution that could put Trump in jail. And Trump's response tells you he knows how serious this is. He's attacking prosecutors, calling it political persecution, threatening consequences. But he's not actually refuting evidence, not saying valuations were accurate, not explaining why documents were destroyed, not addressing why lawyers made statements under oath that turned out to be false. He's just attacking process and attacking people. That's what you do when you can't defend on merits. Bottom line is this. Prosecutors just presented devastating evidence of fraud and obstruction, showed Trump inflated property values by hundreds of millions, continued fraud even after civil conviction, destroyed evidence under subpoena, directed lawyers to make false statements to court. If judge accepts this evidence and makes findings prosecutors are seeking, criminal charges could follow. Manhattan DA could bring fraud and obstruction charges carrying serious prison time. And if those charges are brought, if Trump is arrested, pattern of conduct established in civil case could lead judge to order detention without bail, because defendant who destroyed evidence and lied to court while free is defendant who can't be trusted on pre-trial release. So detention becomes necessary, and that would mean Trump in jail awaiting trial. Former president in secure facility facing consequences he's avoided entire life. We're not there yet. Charges haven't been brought. Arrest hasn't happened. Detention hasn't been ordered. But all the pieces are in place. Evidence is there. Pattern is established. Legal framework exists. Only question is whether prosecutors and judges have courage to follow through, to apply law equally regardless of defendant status. To say that fraud is fraud and obstruction is obstruction no matter who commits it. If they do, if system works way it's supposed to, Trump could be facing jail time in near future. Not as speculation, not as political fantasy, as logical legal consequence of proven criminal conduct. That's where evidence is pointing. That's where this is heading. And Trump knows it. That's why he's panicking. That's why attacks are so desperate, because he sees what's coming. Sees that evidence is overwhelming, sees that excuses are running out, sees that accountability might finally be real. This story continues. Stay tuned. because what happens next could determine whether American justice system has integrity, whether anyone is truly above law, whether evidence and facts matter more than power and privilege. We're about to find out, and Trump's future hangs in balance.